you hear me?
Yes, ma'am.
I'm back. You're all excited?
Yeah!
Okay. Woo! Closing arguments. Tell me, someone, one of the most famous closing arguments or something that came up in a closing argument that you can remember. Plaid shirt.
Last year at state, one of the guys banged on the podium and they were broken.
Yeah, you don't want to do that. In the real legal world, something famous that you guys remember? You guys have answered all the questions, you two right here. Go right here. Great. That's my absolute favorite. If this one right here in the purple. Why was that so important? If the glove doesn't fit, you must acquit. Whose trial was that, first of all? Why was that so important, you guys? In the blue hat. Shh. Speak up. It certainly did. To the glove. One piece of evidence. That whole trial, which lasted for however long it lasted, came down to that one piece of evidence. So, you want to make certain your closing arguments are meticulously thought out. That one got O.J. Simpson off completely with that one piece of evidence. With your closing arguments, the role of your closing arguments, this is your opportunity to tell the jury your story without any interruptions, usually, or any objections. So it's your opportunity to get up there and don't recap everybody's testimony. Who wants to hear that? That's going to be incredibly boring. You want to get up there, you want to highlight your scenario, your theory, your logic, your theme. You guys are only going to be as successful in closing arguments as you have been in the preceding stages of the trial. How good have your directs been? How good has your cross been? You can't win a case completely in closing. You can come close, but you can't win completely on closing. That means you've got to prep for the entire length of the trial. Closing is the icing on the cake. Tell me, you guys, Clinton, last year, what was your theme that you rolled through on closing? How did you use that in your closing? Are you the one that broke it? Here he is. You didn't break it? You split it a little? You got really enthusiastic? You guys, a closing argument is not the place for you to recite your entire case. Nobody wants to hear that. Within the first minute or two of your closing, you should communicate 3 things to your jury. You want to communicate what your theme is, shattered dreams last year. You want to communicate why the jury should find in favor of your client or your side. You also want to convey your enthusiasm for your case. How do we do that? We bang on the podium a little, okay? We use evidence. We use a glove. We use exhibits. Convey your passion. Convey your argument for your side, okay? Argue. Nobody wants to hear anybody get up on closing and give a flat recitation of, this witness said he saw the car here. This witness said they saw the car there. Nobody wants to hear that. You guys get up and argue. Be passionate about your case. That's your only true point where you can do it and not draw an objection. You want to use your arguments to talk about your theme. You want to use your arguments to talk about your theories. You want to use your argument to talk about the supporting evidence that you have in your case. Be efficient. What do I mean by be efficient in your closing arguments? Do you have an hour up there typically to use a closing? No. So what do we need to do when we're preparing a closing argument? Exactly. What do you mean by that?
Only the most important aspect should be brought in. You can't worry about all the fluff.
Okay. Now, when you say only the most important aspects should be brought in, should you spend most of your time on closing bashing the other side? No. Why not? That's a slippery slope if you do that. Because number one, if you spend your entire time bashing the other side, the jury's going to think, well, what about your case? What about your evidence? Where is that? Now, you do want to spend some time distinguishing between your witnesses and the other side's witnesses. You want to talk about either their demeanor or how they contradicted themselves, something of that nature. But you want to do it quickly and you want to do it efficiently. You don't want to spend your entire closing bashing the other side. Do we want to ask the jury for a specific verdict? Why? They have to know what you want. That's correct. Whenever we also tie our theme and our theory, our buzzwords into that, are we going to talk about the law? You're going to talk about the law. Why? That's right, you're a lawyer. You're not going to get up there and say the facts of this and the facts of that and the facts of this and not tie it into what your ultimate request is, which is based on the law. Okay, that's very important. You do want to ask your jury for a specific verdict, always. Don't leave them hanging. You give them all these facts and evidence, but don't say, this is how your outcome should come out, or this is what I want from you. Okay, you have to give them a request. Please return a verdict in the favor of my client. However you want to state that. That's very important. You have to be, your theme has to be a constant presence. If you're going to harp on that in your closing argument, you want to make sure that you've used that theme or that theory or those buzzwords all throughout the trial. Throughout your direct, throughout your opening, throughout your cross, throughout your close. It has to be consistent. Use conclusions to make your closing more effective. Use conclusions about someone's evidence or about someone's testimony. Use inferences that you've drawn excuse me, from someone's testimony or a direct examination. So based upon Mr. Jones's testimony regarding the vehicle, we can infer that there was no blood in the vehicle. Okay? You can do that in your closing. That's the only point where you can. You want to refute your opponent's case by pointing out only their inconsistencies, their implausibilities, and their errors. Like where a witness has been impeached, or where they've misconstrued an exhibit, or where they have presented some sort of implausibility. Do you want to get up there and just say, oh my gosh, they made no sense? No. Why?
Because you need facts.
You need facts. You got to back it up. Base it on facts. Base it upon when you saw Mr. Jones testify about no blood in the car, back it up. Use a fact. Okay, but you want to use it logically and you want to use it quickly. Don't consistently bash the other side. You do want to throw in what their implausibilities are, what their inconsistencies are, and move on. What's your question? What if something is brought up in the closing that wasn't? That's going to be, did a witness testify about it? How logical do you think a jury's going to sit there and think, this is the first time I've heard that fact throughout the entire case. Not a witness has testified about it. Nobody brought it up in opening. Do you think that fact's going to be credible in closing? No. No, it won't be credible. Your jury's going to be scratching your head saying, wonder where that came from. Why did they just throw that in there now? If you're using it in closing, then it's got to be important. So you want to make sure if you're using a theme, theory, logic, fact in closing, you've used that throughout the entire breadth of the case.
With that scenario that you just brought up, if someone did bring up a fact that was non-evidence, do you object and say, Your Honor, you stand up and say, Your Honor, if I could have objected, I would have objected?
No, I wouldn't do that.
Okay.
Not on closing. The reason being because they're going to reciprocate and do that to you whenever you're closing. Do you want your closing argument interrupted? No. No. You guys can discuss the demeanor of your witnesses. You can talk about whether you think they were credible, why you think they weren't credible, those sorts of things. Most of all, you guys have got to apply the law to your evidence. Don't just throw all these facts out there to your jury and not talk about the law at all. You have to apply the law to what you're talking about in your closing. The format of typical closings are either the plaintiff or the prosecution has to go first with their argument in chief. They have to prove to the jury why they're asking for a certain verdict. Then what does the defense do? What do?
They prove why the prosecution's wrong.
They want to prove why the prosecution or the plaintiff shouldn't be awarded the verdict they've asked for. Then what happens?
Well, usually the prosecution has asked for rebuttal after sort of.
Prosecution or plaintiff asks for rebuttal. What happens in rebuttal?
You re-argue the defense's case.
You do, or you can point out what the defense's, their lack of evidence was whenever they closed. But you have a brief amount of time. So you can either do that, or what else, if you're reserving time for rebuttal? Go back to your theme, go back to your theory, go back to your buzzwords, those sorts of things. But those can all be woven in and thought out logically in a rebuttal while you're refuting what the defense has said in their closing. Okay, questions? No questions? Joe, you've got a question, I know. What's the purpose?
So basically, just summarize your point and make your final verdict in your favor.
Correct. You want to summarize your case without going into detail as to what every witness said, using your arguments, using persuasion, using your passion, using your themes and logics, and asking your jury for a specific verdict. Blue. That's exactly right. You want to logically tie all of your evidence, all of your exhibits, all of your facts in together. Back. Speak up for me. You do. You want to prove a point. That's absolutely the whole point of your closing argument.
It's basically not what you need to influence the judge.
Shh. Are you trying to influence the judge? Jury. Yeah. Yeah. You're trying to influence the jury, of course, which hopefully your jury's been paying attention during the whole trial.
I have a question.
Okay.
How prepared should your closing statement be before the case?
Your closing statement needs, especially if you're a prosecution or plaintiff, it needs to be very prepared. Very prepared. Because why? You're going to want to highlight everything that you've done throughout the whole trial. Can you do that on the fly? Typically not. You want to highlight everything that you've done. You also want to go back through those important exhibits. So you're going to want to know what you're going to use. Is that going to change if you're on defense based upon what the prosecution or plaintiff have done? Absolutely. But you still want to prepare. You still want to have those key exhibits ready to show, those key arguments ready to throw out there to your jury. Ms. Judy?
What's allowed in closing arguments is not allowed in opening statements.
You guys answer that?
You can argue the law.
Yeah, you can argue the law. What else? You can draw conclusions in closing. That's important. What else? Anybody else? Black hat. Well, when you're doing an opening, you're not specifically asking them to find something, but what are you asking them in opening? You're going to say, basically, the evidence will present to you such and such, won't you? Which is going to direct your jury towards basically what verdict you want. And then in closing, you're going to follow up and specifically ask for that verdict. Questions? Anybody else? Nope. Okay, Miss Judy. As you just sit down.